Well, hello everyone. Thanks for joining us. My name's Nick Mitchell, Head of Distribution at Netwealth. Thanks for joining us today for a very special webinar, which will be presented by Claire Wivell Plater, who is the Chairman of the Fold Legal. Now, before I do introduce Claire, I want to let you know that a few fun facts. This webinar is being recorded, so slides, recording and podcast recording, they'll be sent to you early next week. Over the course of today's presentation, do feel free to enter your questions in the chat box. We're going to do our best to answer all of those at the end of the webinar. If you're posting to social, make sure to use hashtag NetwealthInvest or tweet at NetwealthInvest. This presentation is allocated to CPD point. A questionnaire will be sent within the next week for you to claim that CPD point. Now, to introduce our esteemed speaker, Claire founded the Fold Legal in 2002 to meet the need of startups and mid-sized businesses for financial services regulatory expertise. Previously, Claire was a partner at Phillips Fox, which is now DLA Piper. Claire currently applies her experience in financial services and insurance law to the regulatory and commercial legal issues associated with fintech, blockchain and financial advice. No doubt a very busy lady. We're really excited to have Claire here today, and I should say, Claire, you're actually making history today. This is the first time in the history of Netwealth's webinar series that we've had over 1,000 people register. So I'm very happy to hand it over to you.
Thank you very much, Nick. That's a great honour. What I thought I'd do is just talk a little bit about what we're going to cover today. I thought I'd give you a bit of a reminder, because the title of the topic is Best Interest Duty 5 Years On, and we're marking the 5-year anniversary of the introduction of the Best Interest Duty by looking at the implications of the duty for advisors in depth after a number of ASIC regulatory interventions and, of course, the Royal Commission into Financial Services, which is still going, but we've learned a lot from the evidence that's been given and the submissions that have been made about the way the Royal Commission is thinking about best interest duty and how it's played out over the last 5 years. So I'm not going to go through these and read them out to you, but you can see the topics that we're going to cover today. And then at the end, I'm going to just talk a little bit about my view, and it is the world according to Claire, about what I think the future looks like and where we're heading. And this is really trying to read between the tea leaves of what the Productivity Commission are saying, what Treasury are saying, what the Royal Commission is saying, and even what ASIC's saying to some extent. So let's start by having a bit of a best interest duty refresher. What people don't realise is that while best interest duty came in, the fundamental underlying obligation to provide appropriate advice didn't really change. But we added to that a positive obligation to act in the best interests of the client and to prioritise the client's interests. So you can see that the items that are in italics are the new elements that were introduced in July 2015. The other two items were always there. So, well, what does this mean, this best interest thing? And basically, it means the advice should leave the client in a better position. So, and that's because consumers who seek financial advice expect that their advisor will leave them in a better position once they have provided advice. So the way ASIC looks at that is it looks at whether a reasonable advice provider would think that the client is likely to be in a better position. So that means the advice does not have to be perfect. It's an objective test. It's what a reasonable person would think. And that depends on a bunch of things, like what position would the client have been in if they didn't follow the advice? And you don't assess that with the benefit of hindsight. You assess it based on what the position was at the time. And it also depends on what advice the client sought and what they were seeking to achieve, their objectives and their needs. And if there's any product features that clients particularly value, then it depends on whether the client understands what those features are and is prepared to pay the cost of those features. But the one thing that ASIC does say is the benefit that they get must not be just trivial. It has to be more than trivial. So it needs to be meaningful to the client. And so that is a slightly subjective test as part of it. So what do we mean by appropriate advice then? Going back to what happened in 2013 was we got a little bit more guidance on what is considered to be appropriate advice. Again, as I said, it's not expected to be perfect advice. The key questions are, will the advice achieve the client's goals, and will the client be in a better position if they follow the advice, or at the time the advice was given, is it likely, would a reasonable person think that the client is likely to be in a better position if they follow the advice? Now, there's 3 times at which we look at this. We look at it when we assess potential breaches of the best interest duty. We look at it when we look at whether someone is satisfying the safe harbour, which I'm going to talk a lot about in a moment. And we look at this when we're assessing potential breaches of the appropriate advice requirement. So they're the times that we look at whether a reasonable advice provider would think the client is likely to be in a better position if they followed the advice. Remember, it's always okay for an advisor to tell a client not to change anything. And indeed, if the client is on track, ASIC's view is that it's more appropriate for you to tell the client not to change anything. What you're doing at that point is giving the client, if that's the case, you're giving the client the comfort and in the knowledge that their current plan and their current trajectory is what they need, and that is actually valuable in itself. So let's look at the other part of the test, which is this client priority rule. Basically, if there's a conflict, advisors have to give priority to the client's interests. And so the real kicker in that statement is, well, is there a conflict? And you need to look at, well, when do these sorts of conflicts arise? And we'll look at this a bit more later in the talk when we talk about vertical integration. But 2 key areas where conflicts arise might be where you have a product where you recommend a product or a service that will create extra revenue for you as an advisor rather than the client. And the classic example there would be, for example, recommending the client invest when it might be better for the client to pay down their mortgage. Or alternatively, if you recommend an in-house product which creates extra revenue for you or someone related to you, when maybe that's not the most appropriate product for the client. So basically, if you recommend an in-house product, ASIC will presume a conflict. And to disclose that conflict is not enough. You actually have to be able to demonstrate that you gave priority to the client's interests. And so it's really important to keep records of your reasons that clients use in-house product, so the basis for the recommendation can be revisited and justified in the event of regulatory scrutiny, and I'll talk a bit more about that later. Another problem and issue that advisors need to think about is over-servicing. So if you recommend to a client that they take up a service level or even arrange their investments in such a way that it will create greater revenue for you, then that could potentially be considered to be over-servicing the client in order to further your own interests over theirs. So again, when you work out what service level or type of service that you're going to offer to a client, then you really do need to make sure that that service level is appropriate. And again, I'll go down into a bit more detail on what that might look like later in the webinar. So here are just quickly some things to avoid, and this, we know we've all seen this before: one-size-fits-all advice, unjustifiable switching, being inflexible about the products you offer, over-servicing clients, as I just mentioned. You really need to be careful not to give advice that requires expertise you don't have. That also is a breach of the client priority rule and a breach of the safe harbour. You must help clients to prioritise their goals, particularly if their goals conflict. They might want to pay down their mortgage and they might want to create wealth. Well, they need to prioritise those goals, and it's really important for advisors to make sure that the priority is appropriate and that a reasonable person would think it's appropriate. I've mentioned safe harbour a couple of times now, so let's just have a look at what this safe harbour actually is. You will have had this drummed into you many, many times, I'm sure, by your compliance managers, and maybe you've got safe harbour checklists or best interest checklists and that you've been working with. So I don't want to talk about the detail of the safe harbour because that's not the purpose of today. Today is really about looking what's happened with safe harbour. But I do want to just go into some background about what it is. It's a statutory framework that provides a partial and not very effective defence against a claim that an advisor failed to act in a client's best interest. And the theory is that if you can demonstrate that you complied with these processes, these 8 steps, then you can dispute the claim that you contravened the best interest duty. Now, what I've just said is widely accepted and understood. and it's definitely set out in the explanatory memorandum to the legislation and also ASIC's regulatory guide, but it does not appear to be being implemented in that way in practice. Unfortunately, an increasing number of licensees, and more alarmingly ASIC, appear to use the safe harbour both to prove a person's compliance with the best interest duty and to establish the actual quality of the advice that you're providing. So we need to be clear about this. Despite the fact that the law says that an advisor satisfies the best interest duty if you prove that you followed each of the safe harbour steps, in fact, it doesn't necessarily prove that you acted in the client's best interest. It doesn't complying with safe harbour doesn't necessarily prove that your advice is appropriate for the client. And your advice process might possibly support the assertion that you complied with the law, but it doesn't prove it. Because at the end of the day, if a reasonable person doesn't think that the advice is in the client's best interest in the sense that it is likely to mean that they will be better off in the future, then it cannot possibly meet the best interest duty. But the problem is that both ASIC and licensees seem to be using the safe harbour as the principal and in some cases the only means of assessing compliance with the best interest duty. So why do they do this? Well, it's convenient and it gives them a consistent method of doing so. But in our observation, it's not leading to improvements in the quality of advice. It's just a new version of form over substance. Version 1 of form over substance in compliance checking was to check that the SOA contained all the information required by the section 947B or C or D, which are the relevant sections. But this is version 2. Version 2 takes more work. It does add off checking the safe harbour steps to the first list. But my view, very strongly, and the view of many of the compliance professionals, is that the true test should be the one we looked at earlier, and that is, would a reasonable advice provider think the advice would put the client in a better position? So what's happening 5 years on is we're getting a very clear and not necessarily, in my view, helpful message, and that is, if it isn't documented on the file, it didn't happen. This is another version of form over substance. So good advice not documented, and I have to thank my colleague Simon Carradis for this image. It's like a tree falling in the woods. Trees don't make any sound. Take them into the paper mill, turn it into reams of paper so you can keep proper documentation, and then that tree falling becomes meaningful. So it is true that keeping records of compliance with the best interest duty is the law. Section 912G requires that. And if you look at the details of various ASIC reports, you'll see statistics showing massive numbers and the predominant proportion of advisors who are not able to demonstrate through their records compliance with the best interest duty. But as I said earlier, it isn't that the advisor didn't give advice that was in the best interest of the clients. It's just nothing on the file to demonstrate that they complied with the law. Tree falling in the woods. So when ASIC does reviews of advisor files, which it does all the time, and we're going to look at some of its campaigns in a minute, it generally focuses on documentation. In some cases, they don't even speak to an advisor or a client. They just review files. And that's because it's so much easier for ASIC to prove documentation failure than advice quality failure. Advice quality is subjective. Documentation failure is not. So often advisors can justify the advice verbally, but with nothing on the file, they're guilty until proven innocent. Client testimonials to fill the gap, too slow and expensive, sometimes impossible. Advisor testimonials, ASIC won't have a bar of those. So as we've seen, and we will see, ultimately a lot of licensees end up caving and compensating all the clients regardless of whether some of them received advice that was appropriate because it's quicker and cheaper. So let's look at some of these ASIC activities. 5 years on, what are the implications of this? Well, we've been acting for some advisors that ASIC's taking some action against and who as a result of publicity both before and after the Royal Commission, have been household names in the advice sector, and indeed some who haven't become household names. And either ASIC is seeking to ban these people or their licensee is seeking to terminate their authorisations. We've had two quite high-profile cases, and I should stress this is not all the cases, where ASIC has substantially ignored whether the advice was in substance suitable for the client and has been seeking to ban the advisor because they couldn't demonstrate that they ticked all the safe harbour boxes. Now, even more alarmingly, once we became involved and we found a bunch of documentation that for some reason hadn't been given to ASIC by their licensees, we were able to demonstrate that in many cases, most, if not all, of the elements of the safe harbour had been fulfilled. So what we were seeing there was ASIC was assessing cases on incomplete documentation and taking a compliance by numbers approach to assessing the quality of the advice, and then seeking to ban the advisor even though they didn't have the complete documentation, which is really frightening for an advisor. In some cases, the failings in the advisor's statement of advice were because the licensee had provided a poor, potentially compliant, but often non-compliant template for the SOA to the advisor, which not only were the advisors required to use, but they couldn't get their advice approved or pass a compliance review if they didn't. And so in many cases, the template required by the licensee caused the advisor to fail the SOA requirements. So you will have seen these. You will have seen standard paragraphs to explain why the advice is suitable for the client, many of which bear no relation to the client's actual situation or preferences. Comparison tables to provide replacement product information rather than an analysis of why the replacement is better for the client, having regard to the costs and the differences in the product features. And no provision for the advisor to personalise the demonstration of the long-term effect of the advice for the client. So put yourself in the position of an advisor facing the prospect of even a short-term ban in these circumstances. Losing the livelihood, stripping the majority of the value out of your practice. It's not something that you want to be able to do. And following round 2 of the Royal Commission, we're seeing licensees take a similar approach to terminating the authorisations of advisors. It seems ironic to us that large licensees, having designed and instituted what we regard as an unsafe system of work, are now shooting the foot soldiers for following orders. I mean, if you set up a bonus system at executive level that only rewards increased returns to shareholders, what do the executives focus on? They focus on making money for the company. And how does that flow through to the advice practices? Well, despite the ban on conflicted remuneration, ways are found to ensure that they recommend in-house products. We'll talk about this more in the context of vertical integration. But first, let's specifically look at some of the things ASIC's been doing and where it's been focusing its attention. In 2014, it reported on a massive review of life insurance advice where it reviewed 202 files. Now, what was interesting about this was that 63% of consumers received advice that met the standard. But of the 37% of consumers that didn't, there was a significant difference that depended on whether the advisor was paid an upfront commission model. So if they were paid under upfront commission, the pass rate was only 55%. But if they were paid under another remuneration structure, the pass rate was 93%. So that explains why we're seeing a much more pressure on commissions in life insurance, and now we're seeing pressure on grandfathered commissions as well as a form of remuneration. Then ASIC went on to the wealth management. Just in terms of ASIC's actions, with 5 years of best interest duty, we've seen 1 criminal prosecution, 6 civil actions, which interestingly 4 have been taken in the past 12 months, and 10 planners banned just in the past 12 months. Now, remember, it does take up to 2 years to make a banning order, and we do know that there are a lot of advisors in the pipeline at ASIC who they are seeking to ban. The wealth management project, which is where it's not the advice one that I focused on earlier, but it's a more broader project looking at financial investment and superannuation advice, has actually seen 50 advisors banned in total from the industry, and 2 civil penalty proceedings commenced against AMP and Westpac. So ASIC has been trenchantly criticised by both the the Productivity Commission and the Royal Commission for taking a too collaborative approach. It's tended to accept court enforceable undertakings relating to financial advice matters rather than take civil actions. And that's why, as we saw in the last slide, we've seen more civil actions taken in the last year. So the submissions that have been made to the Royal Commission are suggesting that when ASIC sues one bank and accepts their use from others, which you would have thought, to be honest, was a pretty good use of taxpayer money, given how slow and expensive it is to bring court proceedings. And as ASIC, quite rightly said, they were at least stopping the conduct. But the criticism of ASIC now is that this is considered to be too lenient, according to the submissions made by counsel assisting the Royal Commission. And that's, I think, why we've seen 4 court actions taken in the last 12 months. Another interesting project that ASIC has had is this Fees for No Service project. And it first reported on this in October 2016, and that was a very early part of the project. The December 17 figures are shown on this slide, and you can see there that the large 4 banks and AMP, as well as some of their product issuers, have needed to refund a really quite extraordinary amount of money, $364 million, and there's another $142 million to go, according to enforceable undertakings and press releases issued in the last few weeks. What was really interesting around this, I think, was how long it took for ASIC and these licensees to work their way through exactly how much money needed to be compensated. There were several rounds of investigation where ASIC required the licensees to go back and look more deeply. What was also interesting, and so these numbers have gone up from quite small numbers initially up to these really substantial numbers. And as I've just mentioned, with another $142 million, we're looking actually at $500 million, which is going to be refunded in total, which is a phenomenal amount of money. The scary part about this, I think, is that senior management were aware in some cases that from at least mid-2012 that some customers who were not assigned to an active advisor might not have received annual reviews, and yet they didn't notify ASIC of the issue until July 2014 in one case. And that's why we've seen pretty stringent additional penalties imposed on some of the licensees, in addition to the requirement to refund this large amount of money. And obviously ASIC will be continuing to monitor these compensations and supervise their further reviews. But there's no doubt that the institutions involved in this did make things worse for themselves by not notifying the breach early and not being, I guess, robust in their initial estimates to ASIC. So with all of this, gloom and doom that I've just been describing, you'd be forgiven for thinking that vertical integration is, particularly in the large institutions, might be prohibited. Certainly, if you've been following the media or Royal Commission or ASIC, you might think so. And the big banks are breaking up, or at least 3 of them are. Westpac appears to be sticking fast at the moment. But what we need to remember is vertical integration is not actually banned. It never has been. And I'm going to put my neck on the block and say that it never actually will be, but I'll talk about why I think that later. It's never been illegal to recommend an in-house product. Why do people think it's a problem? Well, laws basically fall into 2 categories. There are prohibitions and there are obligations. Obligations give you a choice. If you choose to do X, then you have to do Y and Z. But prohibitions are things you can't do, right? So that's the case with vertical integration. It's not prohibited, but if you choose to recommend an in-house product, you've got to comply with the obligations. So why are we still talking about this? Well, vertical integration is not just about banks owning wealth businesses. It's about wealth businesses owning product manufacturing, maybe investment advice in the case of non-aligned advisors, and of course financial advice. So it's where you have a combination in the one business of different types of services where the advice that the client is given in terms of what to invest in gives a benefit to the advice group because they have an interest in the investments in which they advise. So we see that in managed discretionary accounts, where the advice business has an MDA service, or even where it has a revenue stream coming from being involved in the investment selection for that managed account service. But then let's look further. How is that different to an advisor who is actually selecting investments from an approved product list? At the end of the day, you're still constructing an investment program for the client. You're still recommending those investments to the clients. So my question about vertical integration is, well, where do you draw the line? And I suspect we can't draw that line. And I suspect the regulators, and the policymakers, when they come to look at this carefully, they will also see that it's very difficult to draw that line. So where does that leave us? It leaves us with having to understand what it is, what the problems are, and understanding how to manage them. So vertical integration has been bubbling around for a very long time. Industry groups, regulators and government have been looking at it, and it came into focus in January this year when ASIC released a report called 562, which looked specifically at vertical integrated institutions such as the Big Four banks and AMP and conflicts of interest. And it found that 68% of client funds were invested in in-house products out of 200 client files, and 75% of those files were non-compliant. Now, what's interesting here was what the two main areas of non-compliance were. Well, number one was advisors were not properly documenting their product research. And interestingly, that wasn't so much about the product that the advisors were recommending. It was the research on the client's existing product. So in other words, they didn't look at the client's existing product and consider whether or not that product was going to meet the client's needs. It would be adequate to meet the client's needs. They understood the product they were putting the client into, but they really weren't adequately documenting that they had considered the existing product. And so, of course, they didn't then explain why it was that the recommended product was more suitable for the client, linking back to their objectives and needs, than their existing product. So what ASIC saw was a lot of unnecessary product replacement, because they felt that the existing product would have been suitable for the client's needs and objectives. Now, even in that report, though, ASIC said that they saw the benefits of vertical integration. They understand some clients value the convenience of dealing with a single institution. They understand that vertical integration creates economies of scale that should lead to lower cost advice. And this, of course, can improve access to advice. And they understand that clients like the safety of dealing with a single institution with a big balance sheet, particularly when problems arise, because they won't pass the buck. And to the institution's credit, although it's maybe taken longer than everybody would like, they are standing up and they are compensating clients. And all of the CEOs have been very plain that they will put clients back into, as much as they can, the position they would have been. So if vertical integration is considered to be is not going to be prohibited, then what is it that we need to do in order to manage it? Well, it comes back to these elements of the best interest duty that we looked at earlier. Three main obligations, which are up on your screen, and they are all related. And of course, we've covered these already, so I won't go over them again. But what I will do is I'll have a look at how they work in the context of vertical integration. So let's look at an in-house recommendation. And I'm talking here not just about a bank or a financial institution. I'm talking about you with the APL, your own APL, even though it's not in-house, but it is the product that the products that you have determined to recommend. So it is even though that you may not have an interest in those products, they still are the ones that you recommend, and this applies to you even though it's not an in-house product. But if you've got a managed account service, then that may well be considered to be an in-house product. So the first thing is, number one, you need to look at whether the in-house product is suitable for the client. If it's not, then you've got to research external products, or you've got to decline to advise the client. And you need to provide reasons to justify your recommendation. And that analysis needs to be summarised and documented on the client file and summarised in the SOA. So if you do decide to change, what do you need to do? Well, as I said earlier, you must research the client's existing product. What do I mean by that? It is that you need to perform a like-for-like comparison, because this is where things get risky. If the existing product is able to satisfy the client's needs and objectives, it's going to be very, very difficult to justify a recommendation to replace it. So, and this applies whether you're proposing a replacement with an in-house product or not. So you can't have a one-size-fits-all approach to replacing a product. You need to look at each client individually to determine whether the change is appropriate, having regard to the taxation implications, loss crystallisation, the relative cost of the existing arrangements, their need for the features of the replacement product, and whether the product will be more likely to achieve or exceed their objectives than their existing products. And you really cannot do that without a side-to-side comparison. So basically, if the overall benefit of the replacement product is not likely to be better than the existing product, unless, of course, it's outweighed by cost savings, for example, then your advice to replace is generally going to be considered inappropriate. If the cost of the new product is higher than the existing product, then unless, and this is the converse, unless the replacement product will better satisfy the client's needs or be more likely to meet their objectives, then your advice to replace is unlikely to be considered to be in the client's best interests. And remember, when you compare costs, you've got to take all product costs into account. So that means, depending on what structure the client's in currently, you've got to look at platform fees, you've got to look at investment management fees, you've even got to look at if the product is something which is going to require ongoing advice, like an SMSF, the potential cost to the client of the ongoing cost of service of obtaining that advice compared to the client's existing product. And for superannuation in particular, obviously clients need to be advised of and understand the impact that paying product and advice fees is likely to have on their retirement balance, so they can make an informed decision whether to retain the advisor's services. It's fascinating that Australian Super are reported to have doubled their inflows in the month of August, following the last Royal Commission. So people are pouring out of public offer retail super funds and back into industry funds at the moment. That is a phenomenal amount of money. So what we don't know is how much of that is due to advisors putting them back into industry super, and perhaps having different arrangements with them whereby the client pays them a fee to give them ongoing advice about their industry super, or whether it's actually clients voting with their feet and leaving their existing retail super and going back to industry super. So I guess what we're seeing there is that, the Royal Commission has created an incredibly heightened awareness and a very active population of people who are taking an interest in their super, and whether this will continue and how long it will continue for, we don't know. But it's a very good indication for advisors that, clients will, once they understand these things, and they certainly have a better understanding now, they will take action. So you've got to be able to explain to the client what the reasons are for replacing their product or putting them into the services that you are recommending to them. And they've got to be proper reasons, not Wally reasons. And these are some pretty standard Wally reasons that we see in statements of advice. These are actually not reasons for replacing products that are in the client's best interests. And ASIC and FOSS and the FPA have been critical of advisors using generic reasons like this to switch to in-house product, or reasons that benefit the advisor more than the client. But there are better reasons to justify a switch recommendation. So, for example, you wanted a lower cost fund and the recommend fund has lower fees and costs than your existing fund, or you wanted fixed insurance cover that doesn't reduce as your age. Your existing fund doesn't offer fixed insurance cover, the recommended fund does. So if you can find product features that are important for the client, no matter whether it's an in-house product or a replacement product, and on balance, both the features and the cost, when balanced against each other, are going to mean that the client is better off, then yeah, by all means, you can justify a product recommendation. A very interesting new development on the horizon is a regulatory focus on target market, on product suitability. So we've talked a little bit about form over substance already in this webinar, and one of the things that one element of the new product power that ASIC is likely to get fairly soon, or as soon as we get a government that can get something through a Senate, is not just ASIC's power to remove a product from the marketplace temporarily if it doesn't like the product, but it's an obligation, and people don't know about this. There's not been much publicity about this, but it will be an obligation that is placed on both the product provider and an advisor to work out for whom the product is suitable and actually formulate a strategy about that. So what that means is advisors won't be able to begin with the premise that a client will go into a particular product and then formulate a strategy around that. And I know you don't do that personally, but you know other people who do. It's going to have to be the other way around. Strategy is going to have to come first. Then once the strategy that the client, that you're forming for the client in terms of, super versus paying down mortgage, in non-super investment versus super, what type of life insurance inside or outside of super. These are key strategy planks that you work out first. Then the second part is work out whether the existing product is suitable, as we've already seen. And you may need to get used to not recommending products to a replacement to some types of clients, because it's better just to say no. But then there will be this key suitability obligation. So if you want to look like this guy, and this is really important for licensees particularly who recommend in-house products, then you're going to have to develop a suitability policy which describes the attributes of clients for whom, if you have an in-house product, that product is suitable, or even if you have service levels that you've determined for different types of clients, that you work out for which clients and be clear about for which clients those service levels are suitable. Or if you have a managed account service, you work out for which types of clients and the features and attributes of those clients your managed account service is suitable. It's probably a good idea to have someone help you verify that, have an independent person verify that, and then document your process for determining the suitability of your products, your in-house products if you've got them, or your service proposition for your clients. In other words, and what do I mean by that? Well, I really mean saying, okay, let's say we've got 3 levels of service. It's the bronze, platinum, and gold. The bronze goes to clients who have this, and you've got that documented. The gold is offered to clients who have certain features, and that's documented. Those features are documented as well. Same with the platinum. And then advisors are trained on that. And then each client is assessed and told what the differences are between the various levels, given the opportunity, told what you think is suitable for them, but of course given the opportunity to dial up or dial down should they wish to do so. Similarly, if it's a product, if a client doesn't fit that criteria that you have determined that product is suitable for, then you're going to have a pretty good reason to be recommending that product to them. So essentially, the advisors will need to perform a suitability check before recommending an in-house product or an in-house service, or even, ideally, a product on your approved product list, because each of those will need to have some criteria for in what circumstances they are suitable. And this isn't just limited to whether something's suitable to go into a balanced or a conservative portfolio. It relates to things like time horizon for investment, risk tolerance, et cetera, and of course the client's objectives. So these suitability policies, in our view, will need to be carefully implemented by incorporating both the policy and appropriate processes for making sure that the policy is followed into advice policies and procedures. It may be a checklist. It may even be something that you're able to automate, which would be fantastic because it would reduce the time involved in following this. And look, I am not a checklist fan for checklist's sake. I'm not. What checklists are useful for is demonstrating that you've done certain things and also getting you into the habit of going through the process rather than skipping steps. So remembering the tree in the woods, even though a checklist, it might look like a boring thing to do, it will at least give you the documentation that you need in order to demonstrate that you've done these things. Now, also, if you implement a suitability analysis, each advisor will have to be trained on this, and you're going to have to monitor adherence to it by including it in your monitoring, supervision and consequence management procedures, and periodically reviewing whether or not that policy and procedures are actually continuing to work and are appropriate, because of course products change, people change, your client profiles might change, the composition of your client base might change. So you're going to be needing to make sure that these triaging, if you like, or categories that you've created for recommending products continue to be relevant for your client base. Now, I guess you probably heard this here first, and you probably think, oh my God, bloody lawyers and bloody compliance people, excuse my language, they just love process. And look, I would be the last person to say, you've heard me talk about form over substance. I detest form over substance. I think substance is what is important. But what I will say is that sometimes when you're in the habit of doing things a particular way, and you're unconsciously competent, because you can make these determinations that I'm talking about and these assessments very, very quickly, it can be very difficult to make change. And so that's why, taking a step back and having a checklist and slowing down the processes a little bit and making sure that you go through each individual step can be a good way to make sure that people actually don't fall back on the way that they've always done stuff, and that they are mindfully making sure that they go through the process of ensuring that the existing product, checking whether the existing product might meet somebody's needs, and then comparing it to the new product, and then being as objective as they possibly can be. And these are new habits. Like they for most advisors, these will be new habits. And that's shown by ASIC statistics that demonstrate that the majority of advisors don't look at existing products. So what I am recommending to you that is be a little formal about this in order to make sure that this change is sustainable in your business. If it is the case that you want to have an in-house solution, and in the end, businesses who do this are generally quite good businesses, because, and I'm talking MDAs, I'm talking even, someone who creates their own in-house SMA or even a managed investment scheme, then, and you truly believe in it and you understand for whom it's suitable, then my advice to you is to be loud and proud. Understand that your offering won't be suitable for all clients, but if it is suitable, a great choice for your clients, and you are you've gone to the trouble of building your own products like an MDA or an SMA, then be loud and proud about it. There is nothing wrong with offering to manage clients' investments in accordance with your preferred method of doing so. That's what good advice practices do. So if it's your preferred style to only use a particular platform, or to only manage clients' investments via an MDA or an SMA service, that's okay. But if this is your philosophy, or even if you don't say that it is, but in effect it is because that's all you do, which we see a lot of, then you need to be open and transparent. If you lead clients to believe that you've considered other products when you haven't, not only do you fail the best interest duty, but you're likely to have engaged in misleading and deceptive conduct. So if you believe in your investment approach, your advice approach, or even your in-house product, don't hide it. Be loud and proud. This needs to flow through to all your documentation. Your website and other marketing collateral and your financial services guide should clearly identify the clients that you seek. In other words, those for whom your services and products, if you have them, have been designed, and explain how you service them. For example, if you only provide ongoing investment services through an MDA service or an SMA, or if you only operate using a particular platform, then be really clear, because this will help clients to understand from the outset how you're going to service them. The key with this, though, is to know when to say no and to be prepared to say no. And this gets back to the suitability policy. So what do I mean by that? If you identify the criteria that clients need to meet in order to be suitable for your service model, then just don't take on clients who don't fit that criteria. If you're not prepared or you're not able to fit your style to any client, and I'm not saying you should be doing this, then choose your clients to suit your style, not the other way around. The risks just aren't worth it. We do a lot of work in the MDA space, and particularly since the changes last year. And we have yet to see a client who is doing this well in this space. Some clients just want to offer a discretionary investment service, and that's great. But what we see is they're not telling their clients that that's all they do. So they'll purport to give the clients choice of the way their investments are managed, and clients won't actually know that that's all they do. And they won't necessarily explain to clients in what circumstances they might not take on their services, not take on the client because the services aren't suitable for the client. Indeed, what we see them do is actually not be clear about this and take on clients that perhaps are not comfortable with that service. Other clients in the MDA space we see have two services. They'll have the discretionary service and they'll have a non-discretionary service where they manage the clients in the more conventional way of contacting them each time they need to make a change to the investments. And that's fine too. But again, if you have that model, you still need to be clear about for whom each service is suitable and only agree to provide the discretionary service to clients who understand and are comfortable with its implications. In other words, that you're not going to contact them each time a change is made to the investment. And the other thing I want you to remember is you don't have to shoulder the burden of that decision alone. We see advisors all the time who think that it's up to them to make that recommendation, but it isn't necessarily. You can give the client choice. You can say to the client, based on what I know about you, I think this is going to be the right service to you, but let's just run through the pros and cons. Let's just talk about which one you prefer and which one you're going to be more comfortable with, and then let the client make the choice. And if that is the case, your statement of advice doesn't have to say that you recommend that. It can document your discussion, which is that you've discussed the pros and cons of both and the client has indicated their preference for one or the other. And then you talk about the implications of that for the client in terms of costs and so forth, so that the client clearly understands the implications of their decision. I want to talk a little bit here about value for money. And this really arises out of rounds 2 and 5 of the Royal Commission, which unearthed some quite disturbing practices in relation to advice fees. You'll remember that in round 2, and this is in April, that although AMP and CBA bore the brunt of the onslaught, for the first time in history, the practice of charging fees for which no service is received, and in some cases not even offered, was put in the spotlight. And as we saw, this arises in a number of ways when advice fees are incorporated into a product. Clients are either not advised or not sufficiently clearly advised that they can turn the fees off. And in many cases, they may not even be aware of the service they're paying for. For advisors, this has been overcome to a great extent by the fee disclosure statements, because you have to write to clients each year about what fees you're charging them. But of course, it doesn't apply to grandfathered clients, both in relation to fee disclosure statements and grandfathered commissions. And the second way that advice fees can incorporate is when the client leaves the advisor but stays in the product. So the advisor continues to receive the fee even when they don't have a relationship with the client. So the problem is, of course, that if not all clients need or use the services for which the fee is charged, then the product provider or the advisor could be providing a level of service which isn't commensurate with the client's needs. And that is a breach of the best interest duty. So product providers and advisors both need to examine their overall service offering to ensure that you're not recommending or providing services to individual clients that they don't need or value. This applies regardless of the service level. It could apply to your ongoing advice service. If the client doesn't want or need either that service at all or the level of service that you're charging them for, then you may need to rethink what services you're providing. We've seen a lot of examples where call centre services are incorporated into product cost, but some clients don't value or need those services. And of course, this is really, really important for low balance clients, because paying unnecessary fees can erode their retirement balances. So as I said earlier, it is good practice to offer different levels of service from which clients can select based on their needs and budget. And this is something that needs to be reviewed annually each year. It's not select and lock in here. because clients have different needs depending on their age and stage. And so it's a good idea to look at their likely needs in the coming year and adjust the service level based on what those needs are. And of course, for advisors, and we haven't really seen this drilled down into advice land yet, but if you do that, then it will avoid a situation where you could be charging fees for services that you don't provide. And that's been subject to much adverse scrutiny at the institutional level. But we can read between the tea leaves on that and see that we may well see ASIC look at this value for money issue in relation to ongoing advice services as well. Before I get to my predictions for the future, I just want to touch briefly on grandfathering and what it was, because I'll talk about what's going to happen in relation to grandfathering. Remember back at FOFA, if you invested in a platform before 1 July, then pre and post 1 July investments were grandfathered. So in other words, commissions could continue to be paid to advisors in relation to those investments, but after 1 July, they were not grandfathered. And similarly with investments, if a client directly invested in a product before 1 July, then that investment would be grandfathered, but any contribution made would not be grandfathered. So there was a big difference between platforms and direct investments in products. And you could also do limited switching, but basically any direct investment in a product after 1 July was not grandfathered. So the world according to Claire, and I'll start with grandfathered commissions, is I genuinely believe that we will see an end to grandfathered commissions. I think that they will be banned. Well, first of all, what we're seeing is quite a number of people voluntarily ceasing them. That's tending to happen more in products which are within institutions. Understandably, product providers and the big institutions are not wanting to cut off grandfathered commissions to non-aligned advisors. But I suspect that when you read the submissions to the Royal Commission and you read ASIC's testimony to the Royal Commission about the fact that it never expected that grandfathered commissions would go on for 5 years. They thought that they would be phased out by now. I think what we'll see is at a policy level, we'll see the government make a determination that grandfathered commissions are no longer appropriate and they will be legislated out. It may take some time, like there may be a phasing out of grandfathered commissions, but I think that they will go. Number two, I believe that vertical integration will continue in some form. I don't believe that you can structurally separate the provision of financial products from the provision of retail personal advice, because where do you draw the line, as I said earlier? Instead, what I think will happen is that more attention will be paid to managing the conflicts that vertical integration necessarily entails in the ways that we discussed earlier. I also think that because of the concern around value for money, we will see increased pressure on asset-based fees. And I think that what we'll see, and this is happening already at a grassroots level, it's not widespread, and it hasn't reached even, levels where it would be seen to be a trend, but we are seeing combinations of fixed annual fees, a services rate card. In other words, for this service, we charge a range of fixed fees between X and Y, and even hourly rates where, it's not possible to put a fixed fee on it. We're starting to see that emerge with a number of clients now, people who are really concerned about wanting to have best practice advice practices and to demonstrate their commitment to their clients' best interests. So I think you'll see that there'll be increasing pressure. I think we'll see increased accountability of senior executives. BEAR has come in, and my friends who are senior executives in large financial institutions are really paying attention. They are really concerned about BEAR. They are asking very different questions of the people who work below them than they used to. So I think ASIC may well get a BEAR equivalent for conduct, and that could well extend to more broadly based businesses rather than just the major institutions that are APRA regulated. And I think we'll see a massively increased focus on conflicted remuneration. And what I mean by that is employee remuneration. It will start at the executive level. We've already seen some attention paid to advice remuneration, and we've seen ANZ change their remuneration structures already. But I think we'll see more attention being paid at conflicted executive remuneration, so that shareholder returns will not be as influential in executive remuneration as they have been in the past. So they're my predictions. Now, I understand, Nick, we've got some questions.
Yeah, we've got a bunch of questions coming through. Claire, thanks very much. That is, there's a ton of info in there, obviously highly relevant and topical right now. I think that it's striking, that number, isn't it? The 364 mil for compensation that's either been paid / offered, or, you know, potential future compensation. We're at a very huge turning point for our industry. We're going to try and get through as many questions as we can. You made a point there, and Jeffrey's actually sent through a note. You mentioned hourly rates in the future. Can that possibly discourage efficiency, leading to sort of higher costs for clients, do you think?
Look, I think the key thing about hourly rates is transparency. So when a client, yes, it's a problem, right? But clients will not pay fees they don't think they're getting value for. The problem about even asset-based fees is that they are still relatively opaque, in the sense that they come out of the client's account, and the client sees them when they review their account. Yep. It's not something where you're sending them an invoice and they're approving the payment.
Yeah. We've had a couple of people come through and just ask, what is BEAR? Can you just quickly touch
on
that?
BEAR is the new executive accountability regime, the bank executive accountability regime, which applies to executives of approved deposit-taking institutions, in other words, banks. And essentially, the executives are now personally responsible for failures. It's a power that's been given to APRA. It also means that executives' remuneration structures, their bonuses can be clawed back if there are compliance failures. So as you can imagine, bonuses are a really big part of executive remuneration. So it's really focusing their attention on some of the issues that we've seen, the misconduct issues that are happening a lot further down the organisation, which traditionally have not necessarily travelled upwards at a level that has caused the executives to either know about them or know enough about them to be concerned about them.
Yeah, there is questions come through. This is actually an interesting one. What's the obligation to refund past fees?
That is such a great question. To be honest, my view, if ASIC had the time, resources, and and inclination to look at the entire advice industry, then all advisors who have received fees where they haven't delivered services would be required to refund them by ASIC. Now, the question for advisors now is, well, actually, that is an obligation you have right now. ASIC's made it really clear, the Royal Commission have made it really clear that if you've been receiving fees for services that you haven't been delivering, you should be refunding them, right? And we've only seen that played out in the banks, but there's no doubt that advisors who have been receiving those fees have the same obligation as the banks do.
Yeah, absolutely.
So the question is, do you do a voluntary restoration program in relation to that?
Yeah.
And I mean, that will strike fear and terror into the hearts of advisors, because that can have a very significant financial implication for an advice firm.
Yeah, you're spot on. Now, I don't want to talk about Canberra because it's been in the news far too much over the last couple of weeks, but a good question from Richard, who's very confident about something. Will the future look different under Labor after May 2019? Certainly with regards to your last slot on the world, according to Claire. Will that accelerate the world, according to Claire?
Yes, I think it will.
Yeah.
Definitely, yeah. Well, as we know, the Productivity Commission report into superannuation, the combination of that and what they found about the returns and the costs of retail funds versus industry funds, and the fact that the Royal Commission really didn't get any sticky hits on industry funds, mean that Labor, just gives fuel for Labor to justify in tightening up the enforcement of the regulations on retail super and also advice business. So I think if anything it will accelerate it.
Claire, we have to bring this to an end. Unfortunately, there are a ton of questions still there. So what I'm going to do before I thank Claire formally is encourage all of you with questions to contact Claire via thefoldlegal.com.au. The slides are recording in the podcast, as I said earlier. They're going to be sent to you early next week, so you'll have all this info. There's some great slides in there, which they'd just be handy to have. I'm not going to say pop them up around your desk, but you can look at them. It really breaks the complex down into very, very simple. I know compliance is everyone's favourite topic as well, so I like it when it's broken down certainly into layperson's terms. As everyone knows, the presentation is allocated a CPD point, and the questionnaire will be sent to you within the next week to claim that CPD point. As I said at the top, Claire, we have broken the record for the most amount of people listening into one of our webinars, and it's absolutely no surprise based on the presentation you've given today. So on behalf of all of us at Netwealth and to all of our listeners today, a very big thank you.
It's been my pleasure. Great to talk to you.
Thanks, everyone. We look forward to hosting you at our next webinar coming up soon.